despite the fact that Georgia and Wisconsin both have laws that basically require the prosecution to disprove the affirmative defenses. So, in Georgia, just as much as Wisconsin, you have, if somebody raises an affirmative defense, it is the responsibility of the prosecution to say that the affirmative defense is not valid, i.e., prove the negative. And that's not always how affirmative defenses have been. Affirmative defenses have been done in ways like, for example, let's say I am accused of stealing an item from you. Let's say I have a watch that you owned, right? And you used to own this watch, and I now have possession of it. Now you're trying to claim that I stole this watch from you, and you show, hey, this is a picture of me wearing this watch, and these are the markings on the watch that prove that the watch belonged to me, and so therefore you need to go arrest Dan for stealing my watch and return my property to me as well. So the police come knocking at the door, and they bring me to court, and we have a criminal case over theft of your watch. Now, let's say normally they would have to prove somehow that I had the watch. If they can't prove that I had the watch, or they can't show evidence that I walked off with the watch in my possession from their property, then the onus is on the prosecution to prove that I stole the watch. However, let's say I did have possession of the watch. Let's say that I had agreed to buy the watch from you for a certain amount of money. Let's say I was like, okay, I'll buy this watch for you for $200. We sign up a contract. You agree to it. Maybe I've even put the sale on video. Say, hey, you're agreeing to sign this watch for me. So I could then go in court, say, assuming it made it to court, I could go to the court and say, hey, yes, I have his watch. This is the watch that used to belong to him. But he sold it to me, so I have proof that this watch is now my property. So that is what an affirmative defense should be like. I then show the signatures on the contracts. I say, hey, here is the contract that I bought the item from him. Here's the bill of sale. Here's a video of me buying the watch and him agreeing. Here's the email conversations that we have negotiating the price of the watch and then coming to an agreement to purchase the watch. And here's the canceled check. On the bottom of the canceled check, I wrote watch on it. So here's all of the evidence. I have now proven that I legally bought this item. So that is an affirmative defense. Now, to argue that the prosecution in this case should have had to prove that I didn't steal it. Had to prove that I really did steal it, that I have to disprove a negative. Like, how could they do that? If I say, he sold it to me, how could the prosecution prove that they didn't sell it to me? If the person who's making the accusation that I stole the watch doesn't have evidence of me stealing the watch, how are they going to prove? How is it at all reasonable to say, okay, here is Dan, he's claiming that he didn't steal the watch because it was sold, and that's his affirmative defense. It was a sale and it wasn't a theft. It's unreasonable to say the prosecution has to prove that has to prove that I'm wrong, has to prove that I didn't buy it. No, the prosecution shouldn't have to do that. If I'm saying, hey, I have this watch, and the owner should be on me, the defendant, making the claim that there was a sale, to provide the evidence of the sale. And once I provide evidence of the sale, then that should be enough to acquit me. Now, and that's not taking away my presumption of innocence. That's me saying, here's the evidence that I have. And I'm raising the affirmative defense, and here's the evidence that I have. Let's see, Daily News says, this is your interpretation of how the law works, which is your opinion on how you see the law is written. Well, I'm going to get to that in a second, bringing a boy. Or is this the lovely wife because it's not in all caps? Take for another example. What is another affirmative defense? Another affirmative defense is insanity. I am not guilty by the reason of insanity. So, if I raise the affirmative defense, not guilty by reason of insanity, does now the prosecution have to prove that I'm not insane? No. If I declare an affirmative defense of not guilty by reason of insanity, it is the responsibility of the defense to bring evidence that I am not sane. To bring expert witnesses that will testify to my mental state, to be able to say he was not in his right mind during this portion of time, or he's just not generally in his right mind, so therefore he is not guilty of committing the crime because of his mental issues. So, it is not reasonable to say that the prosecution should, in that case, because of the presumption of innocence, have to prove it shouldn't just be accepted as the fact as, oh, well, he says that he's insane, so we're going to believe that he's insane so that he can get away with it. And then the prosecution has to prove that I'm not insane. Now, prosecution may be able to call another expert witness to be able to try and counteract the testimony that's given to try and claim that I was insane during whatever commission of whatever crime that I did. But still, the responsibility is on me and my defense team to prove that argument because we've raised an affirmative defense. What are you saying yes to? That's correct? Are you agreeing with that one? Okay, so let's go to, I'm looking at Federal Criminal Defense Outline, Assistant Federal Public Defender, Angela Saad, Western District of Texas. So this is from a government website talking about all the different types of defenses that you might have. So let's scroll down to page 18, which lists affirmative defenses. Now, this is affirmative defenses in federal law. And affirmative defenses, yes, it's the job of the prosecutor to rebut, but still, in order for the court to prove, in order for me to prove to the court that I am insane, it's not enough for me to say I'm insane. It's not enough for the defense attorney to say I'm insane. Defense attorneys raise the affirmative defense of insanity, not guilty for reasons of insanity, and then have to present evidence to support that fact. Okay, so let's go to the affirmative defenses under federal criminal processes. So the first affirmative defense listed in this document is duress. So duress was said to excuse criminal conduct where the actor was under an unlawful threat of imminent death or serious bodily injury, which threat caused the actor to engage in conduct violating the literal terms of criminal law. So, let's say somebody has a gun to one of my family members' heads, and they say, go steal this item for me from a store and come back to me, and if you do that, I'll let you and your family go. That's duress, okay? The defense of duress does not negate a defendant's criminal state of mind when the defense requires the defendant to have acted knowingly or willfully. Instead, it allows the defendant to hold liability because coercive conditions or necessity negates a conclusion of guilt, even though the necessary mens rea was present. So to succeed, this is from this paperwork. To succeed on a duress defense, the defendant must show that the defendant or a member of his family was under an unlawful and present, imminent, and impending threat of such nature as to induce a well-grounded apprehension of death or serious bodily injury, 2, that he did not recklessly or negligently place himself in a situation in which it was probable that he would be forced to choose the criminal conduct. And 3, that he had no reasonable legal alternative to violating the law. That is, that he had no chance to refuse to do the criminal act and avoid the threatened harm. And 4, that there was a direct causal relationship between the criminal action taken and the avoidance of the threatened harm. So, and the burden of proof is on the defendant in federal cases. The defendant bears the burden of proving duress by preponderance of the evidence. So, if you were trying to convict me of a crime, the prosecution still has to prove that I did it. However, if I am going to claim that I was under duress, I can't just say I'm under duress and then have the prosecution then be forced to prove that I wasn't under duress. No. Under federal law, I have the responsibility as the defendant, or the defense attorneys have the responsibility to prove with a preponderance standard. So it's not beyond reasonable doubt, but it's just more likely than not that I was under duress, that I met those 4 qualifications that are required for being considered under duress, so that I don't have to face criminal punishment for the criminal acts that I did, because I'm admitting that I did the criminal acts. I'm admitting that I did these acts that are normally considered a crime. I'm just saying to the court that I shouldn't be punished for them, because under the law, if I'm doing it under duress, I am not responsible for legally for doing those actions because somebody else was forcing me to. Again, there was no requirement that this didn't get around. This doesn't eliminate my preponderance of. It doesn't eliminate the assumption of innocence, but it does require that I do have to now prove my argument in my affirmative defense. Let's see. You say the court has the right to say if you're insane. The court has the right to say if I'm insane, but the court needs to be given evidence to show that I'm insane. If we're talking about the insanity affirmative defense, and the responsibility on proving that one is insane rests on the defense to provide a witness to say, yes, this person was insane. Okay. Let's see. Evidence, trial considerations. Evidence in support of duress defense must show that the person of ordinary firmness would succumb to the level of coercion present in a given set of circumstances. In addition, evidence supporting the defendant's state of mind or to bolster the defendant's credibility can be admissible despite hearsay and relevancy objections. Where duress is raised, even if a defendant does not testify, evidence of a prior conviction can be admitted to prove the defendant's criminal intent. And there are jury instructions about that. In sentencing, the defendant can argue for a downward departure under U.S. sentencing or a variance under whatever based on imperfect duress defense. At sentencing, the district court may consider subjective factors demonstrating duress, but not to determine criminal liability. All right, we're going to skip necessity because there's some odds there. All right, self-defense. Federal self-defense. If you're claiming self-defense in a federal court, self-defense is available when a defendant acts criminally in order to protect himself from a real or threatened attack. Like the elements of duress, the elements of self-defense are: defendant was under unlawful, unprecedented, imminent, impending threat, that he has not recklessly or negligently placed himself in a situation where it was probable that he would be forced to choose the criminal conduct. He had no reasonable or legal alternative, and there is a direct causal relationship. The burden of proof in this, the defendant has the burden of production, but not proof when asserting self-defense. And so I never heard the term burden of production. So what did I do? I went and looked up burden of production. A party's obligation to come forward with sufficient evidence to support a particular proposition of fact. Satisfying the burden of production may also be referred to as establishing a prima facie case. Determining whether a party has satisfied its burden of production is not an issue of fact for the jury. It is an issue of law. When a party has satisfied its burden of production, it has produced enough evidence on an issue to have the issue decided by the fact finder rather than decided against the party in a directed verdict, motion for judgment, or motion for summary judgment, also referred to as a burden of going forward with the evidence, production burden. And so a prima facie case is Latin for at first sight. Prima facie may be used as an adjective meaning sufficient to establish a fact or raise a presumption unless it is disproved or rebutted. It may also be used on appearance but subject to further evidence or information. Basically just means on its face. So, going back to the burden. So you don't have to necessarily prove it, but you have to then, you still have to provide, there is a responsibility that the defendant has to provide enough evidence to say, yes, this was self-defense. So again, you don't put all of it on the prosecution in federal cases. The defendant has the burden of production. And there's interesting, when a defense claim is brought in response to a felon in possession charge, the 3rd, 9th, and 11th Circuits has held that the defendant carries the burden of production and proof. So if you're saying, you're a felon in possession, in certain circuits, you are also required to not just produce the evidence, you also have the burden of proof against you. So there are some differing standards, I guess, in different circuits as the way some of the requirements of the law have. What evidence of a victim? We're not going to do about that. Battered spouses syndrome. When the battered spouse syndrome is not well received under federal law, syndrome can be the basis of support for underlying justification defense, duress, or self-defense. Burden, see the elements of self-defense or duress. So it's basically the same thing as either. Let's see. Here's an interesting thing. While under federal guidelines, you have to, if you're defending yourself in some areas, you have to claim self-defense, and you only have the burden of production. But under the federal rules, under the defense of others, so defense of others is affirmative defense for murder, voluntary manslaughter, and assault. A person may use a reasonable amount of force in defending against an attack without being guilty of an assault. The right to defend a victim from attack does not exceed the victim's ability to defend themselves. Who is the burden of proof in defense of others? The burden of production and proof is on the defendant. So the defendant raises the affirmative defense that I was doing an act of self-defense. The defense then has to provide the evidence and has the burden of proof to say that, hey, this was the reason why I had to, if you're charging me with murder of this person, I killed that person because he was going to kill somebody else. So I prevented somebody else from dying by killing that person, and I then have to prove as the defense that I was the individual, that was true, that is a factual and true statement, and I have to prove it just a preponderance standard. Let's see. Government's conduct that prevents access to possible witness who can corroborate the defense of another theory may result in dismissal of the indictment. Trial considerations, jury instructions. There must be sufficient evidence to support a defense of others. Jury instruction. Evidence. The defendant's claim of defending others can be undermined by events preceding the criminal act. A defendant's rationale justifying a criminal act while supporting an accused theory of defense of others can provide evidence of an element of the offense and negate the theory of defense in light of the defense. Let's see. Defense of property. If you're defending property, if an individual's lawful possession of property is threatened by unlawful conduct, the individual may take reasonable steps, including use of force, to prevent or terminate the interference of the property. Who does the burden of proof belong to? In federal courts, the burden of proof belongs to the defendant. Entrapment. Entrapment is an affirmative defense designed to ensure that persons not be held criminally liable for acts in which they were induced to commit. Blah, blah, blah. I think anybody knows about entrapment. We've heard it a lot. Burden. The defendant bears the burden of production to raise the entrapment defense. The defendant must make a prima facie case, though production of evidence that government's conduct created a substantial risk of entrapment. If this burden is met, the defendant is entitled to a jury instruction, and the burden shifts then to the government to prove beyond reasonable doubt that the defendant was predisposed to commit the criminal act. So again, this is a case where there is a requirement on the defense to bring enough evidence to support a prima facie case. Then, at that point, the prosecution has to prove beyond reasonable doubt, which is less, which still shifts some of the burden on the prosecution, but not as much as these state laws do. Withdrawal. So the defendant can contest the intent element required for a conspiracy if there is evidence that he withdrew from the conspiracy. So if there is some conspiracy going on and the person's like, you know what, I got myself out of it, I no longer wanted to have anything to do with it, the defense requires that the defendant show that he affirmatively took actions inconsistent with the object of the enterprise and communicated his intent to withdraw in a manner reasonably calculated to reach his cohorts, and basically said, look, y'all do this, I'm out, I'm done. The defendant's actions or statements supporting withdrawal defense must be of the defendant's volition. And the burden of proof providing the affirmative act of withdrawal is on who? But the defense. Abandonment. Abandonment, renunciation, or withdrawal of criminal attempt occurs when the individual voluntarily forsakes his or her criminal plan prior to committing an overt act in furtherance of the plan. Let's see, Fifth and Ninth Circuit has rejected this defense because the defendant withdraws before the forming the necessary. So the First, Second, and Third, and 11th have acknowledged. So some courts acknowledge it. They don't really go into burden of proof for abandonment. A defense of voluntary intoxication can only be asserted when a specific intent of an element of the crime is charged. Evidence of disease, intoxication, or trauma is proper for consideration by the jury to determine whether there's a sufficient degree of intoxication existed to negate intent. The burden of proving specific intent beyond reasonable doubt is on the government. However, the defendant bears the burden of production. Again, a situation where they're even though the government has the burden of proof for beyond reasonable doubt, there is still a responsibility on the part of the defense to be able to raise some issues. Statutory defense. I'm not going to deal with statutory offenses. Let's keep on going. There's a lot of information for that one. Okay, so that's basically a bunch of the statutory defenses. But like, well, let's just say, for example, determining whether an exception is affirmative defense or an element of defense depends on the statute. So let's say, 18 U.S.C. 922-0, subsection 1 prohibits unlawful possession of a machine gun, but contains exceptions in subsection 2 for lawful possession prior to the statute's effective date, which have been construed as an affirmative defense. So, somebody wants to say, oh, he has a machine gun. That is against the law for you to have a machine gun, right? But if I can say, well, I bought this machine gun, here's the receipt that I bought this machine gun prior to the date when you made it illegal, then that's an affirmative defense. Now, again, it is ridiculous to suggest that the government should be required to prove that I didn't buy it before the date. How would they be able to do so? It's ridiculous. If I'm going to say, all they have to do is prove that I have the gun. Now, I could say, yes, I have the gun, and here's the receipt showing that I bought the gun in a lawful way. Then that's an affirmative defense, and it's the responsibility of me to prove that affirmative defense. Let's see. The burden of the government is the element. If it is an element of the defense, the burden of the proof is on the defense. If it's the exception, so that's what it says. So normally, if the offense is you have a machine gun, the burden of proof is on the government to prove that I have the unlawful machine gun. However, if I'm saying I'm the exception, I get to say well, here's my receipt showing that I bought it, and now the burden of proof is on me to provide that receipt. I can't just say I bought it on such and such date that's prior to it becoming illegal for me to have this gun. And then it would be ridiculous for the courts to then say, well, he said he bought it beforehand. Prove that he didn't buy it beforehand. That's why you have to have affirmative defenses operate in that way. This is why you have to have affirmative defenses have some requirements on the defense, either if it's a burden of production or if it's burden of proof beyond, the was not clear and concise, but preponderance standard. I have to prove with the preponderance of the evidence that it is more likely than not that I bought this gun prior to. Now, maybe I don't have the receipt for the machine gun case. Maybe I have pictures of me or videos of me with this gun before that date. So this picture was taken on such and such a date, and maybe I have a shirt that says, this shirt was available this particular year, or maybe I was at a particular event that was timed, or maybe there's a timestamp on the camera that says, hey, you took this picture and it was this such and such, date, and so this is evidence, by preponderance standard that I had this gun prior to the date where buying this gun became illegal. Again, but it's my responsibility to prove that in court, because that's how affirmative defenses are supposed to work. Yes, the prosecution, and yeah, there is Photoshop, sure, and then that could be debated. But the prosecution has to prove it's a machine gun, and the prosecution has to prove that I own an unlawful weapon, a weapon that's normally considered unlawful. And if they can do that, then they can get me convicted unless I raise the affirmative defense. But if I raise the affirmative defense, it's not the prosecution's job to disprove my affirmative defense in that case. It is my job to provide the evidence to show that by preponderance of the evidence that I am legally possessing this weapon because I fit the exception. But the prosecution might not have Daily News says the prosecution has to prove that picture of you holding a machine gun. The prosecution might not have access to the picture of me holding the machine gun. All the prosecution needs to convict me is me possessing an illegal weapon. Because generally speaking, it's against the law for me to have that illegal weapon. But if I'm going to say, hey, I bought that weapon when it was legal to do so, so therefore I qualify for the exception of the law, the people who support what the affirmative defense has become in these states, like Georgia and Wisconsin, would be arguing that, well, now it's the responsibility of the prosecution to disprove that claim. Well, why then wouldn't anybody say, oh, I bought this gun before it was legal? How do you, if you don't have access to where you bought it, it's not my job to tell, hey, this is where I bought this gun. They have to do that research. But, if they can't find in the research the bill of where it was purchased, well, guess what? It doesn't matter. They don't have to prove where it's purchased, because all they have to do is prove that I have the gun. But because of the affirmative defense standard that is for these types of laws, if I say, yes, I admit it, I own this gun, and I own it legally because I fit the exception, it is my responsibility to prove the exception. And it is a logical fallacy. It is illogical and ridiculous and absurd to suggest that the prosecution would have to disprove my statement. I'm not saying that the prosecution would use the picture as evidence. I'm saying that the defense would use it as evidence. Now, the prosecution could try and fight that. The prosecution could try and say, well, we believe this is Photoshop, so we're going to have this image. Let's say I had an image of the receipt. Let's say I didn't have the hard copy of the receipt. Let's say I scanned in the receipt. Now, I provide this scanned copy of the receipt as evidence showing. Now, the prosecution could say, well, we want to test that image to see if it was Photoshopped. And they could do that. And they could say, hey, this is a photoshopped image. This is not a legitimate receipt. This is not a legitimate proof. And they can call into question the proof that I bring up. And whether or not it meets the preponderance standard or not is what if the jury believes that it's a fake, then the jury is going to convict me for owning an illegal firearm, illegal weapon. But it's still my responsibility to prove my case if I am using an affirmative defense. And that's my point. It is my responsibility in all of these cases that I just talked about. This is not me pulling this stuff out of my butt. This is me reading from a document that is explaining federal procedure when it comes to affirmative defenses. And there's a whole bunch of other stuff in this document too, but this section of the law talks about affirmative defenses and how and who the burden of proof rests on when it comes to those affirmative defenses. The burden of proof resides with the defense in many of these cases, in most of these cases, and in some cases it's just the burden of production of evidence, so that the defense has to show enough evidence to make it on its face to say, okay, here's this is a case of self-defense. This is not a case where it wasn't this is not a normal case. But that's why I believe that these changes that are being made in the state laws are problematic. Because it used to be that the rules were like this in the states too. The states would say, hey, if you are raising an affirmative defense, and then they still do in many cases, especially in civil cases. There are a lot of civil examples that you can use where somebody says, hey, like if somebody was not bringing me under charges, like a crime of thievery, if I'm not being charged with theft of their item, but I'm still being sued in court for having the watch that was theirs. Now they could sue me in court for having the watch, but I could say, well, you sold me the watch. I don't have to say anything. Well, I could just say, prove I have the watch. But I could wear the watch to court and say, look, this is the watch, and here's the receipt. Here's the canceled check where I bought the watch from you. That's an affirmative defense. And the responsibility of the person raising the affirmative defense is the person making the affirmative defense. Only in these self-defense laws in state courts do we see the responsibility of proving. You don't see that you're seeing a change to where the defense no longer has to prove the affirmative defense. The defense has to disprove, or the prosecution has to disprove the affirmative defense. And again, just as it's ridiculous to suggest that the prosecution should have to disprove that I own that gun, legally, like I say, hey, I bought this gun on January 1st, 19 whatever, where it was still legal for me to buy that gun. So it's ridiculous to say, hey, that person didn't, and try to say, the prosecution has to then say, well, he didn't, and then try and prove that he didn't. No, the person raising the affirmative defense has to prove that he did. And once that happens, then it's an affirmative defense and accepted by the court. So the fact that we've changed that here, where like federal law and state courts are clearly, they're two different things. You have different procedures in state courts and federal courts, and it's understandable. But, people say, well, what happened to innocent until proven guilty? Every time I talk about this, every time I talk about how we've changed how we handle affirmative defenses, people are always like, well, what about the presumption of innocence? What about it? You still have it. If they can prove that you killed somebody, then they could prove that you killed somebody. But just like in federal court here, if you're claiming self-defense, you have the burden of production, but not of proof, while asserting a self-defense claim. Again, while a self-defense claim is brought in response to whatever, that's fine. But you have to bring the evidence to show in and of itself that on its face, that this is a self-defense case. You have to provide evidence that this is self-defense. Period. And it's reasonable to expect that if you're going to say, yeah, I did it, but here's why me doing it is legal, that you should have to say, here why me doing it is legal. You shouldn't just be able to say, yeah, I did it, but it was self-defense, and then require the state to now have to disprove self-defense. No, there should be some requirement on the defense to establish a self-defense claim. And that we've moved away from that has made it much easier now for people to get away with murder. It's how George Zimmerman got away with murder. It's how I believe Kyle Rittenhouse got away with murder. And a lot of other people are going to get away with murder too because of it, because we have taken the onus off of the self-defense claims from the defense. We have told the defense that all they have to do is say self-defense, and then it all gets thrown on the prosecution. And while I agree with the general principle that it's better for 100 guilty people to go free than one innocent person be locked up, I don't believe that we should be tying the hands of the prosecution so much that you are forcing them to prove a negative. Because when you start forcing prosecutions to prove a negative, you start making it impossible for them to do their jobs. And while their jobs should be to seek justice, and unfortunately there are too many cases where you do see prosecutions trying to make a career for themselves instead of trying to, just seek the truth. There are times where people were, the Duke lacrosse rape case, for example, that attorney was trying to have a career case and ignored evidence and, just had blinders on and was just trying to make it his importance. What was important to him seemed to be getting a conviction, not seeking the truth. The prosecution should be always trying to seek the truth. And I have a big problem with prosecutors who are just trying to make career cases for themselves. You should make a career case for yourself like the attorney did who in the prosecution there down in Georgia, because she was spot on. She was excellent. She did a great job prosecuting that case. I mean, it's my opinion, and I've tweeted this out, that if she would have been the district attorney over in Wisconsin, that she might have been able to get a conviction of Kyle Rittenhouse. Maybe, maybe not. I think she's far more competent than Binger was. But at the end of the day, she was even able to overcome the hurdle of the requirements of self-defense because just the evidence was so overwhelming in this case that the McMichaels and Bryan were guilty, that she could overcome that and she could disprove the self-defense. But there are going to be cases where people were not acting in self-defense but were putting the onus on the prosecution, makes it so that it's difficult for or near impossible for them to prove murder, what really was murder. And that's my point with this. So if you agree or disagree, you leave a comment down in the YouTube section below. If you can like, share this video. I've been recording this last part. I might make this into a standalone video about affirmative defenses, or I might just make a new one. I don't know. But at the end of the day, I really think that we would be better off if we did go ahead and go back to how affirmative defenses were. Now, look, I'm open to arguments as to why we needed to move it this way. But I fear that the reason that we moved this way, the reason that we changed the laws, was because of ALEC, the conservative group that likes to create model legislation that is very pro-conservative. And I'm concerned that the reason that they made these rules was to protect certain groups of people and to be able to make it harder for people to be prosecuted and convicted of crimes that they should be convicted of, because the actions that they're doing should cause guilty convictions but are not, because you've set the burden so high and you've made it so impossible to convict these people that they can just get away with murder. And that is not justice.